welcome to the ECA's webinar on prompt payment and construction lien legislation. What you need to know to get prepared. So we're really happy. I think we're going to have about 180 different attendees today. So there's a pretty good cross section of people from across the construction industry. So as you're all aware, there are some fairly important legislative changes that are coming to our industry. So the ECA and the Alberta Construction Association kind of got together and said, well, what can we do to help prepare our members, our respective members, with respect to the changes that are coming to the regulations and legislation. We've been very pleased to partner with Gowling, WLG. They've been doing webinars on this very subject on behalf of ACA and all of the local construction industries associations across the province. Gowling WLG is a team of about 1,400 legal professionals. They've got 18 offices worldwide, and they are really experts in the construction law field. So before I get into introductions, I'm just going to make a land acknowledgement, as we do before all of our meetings. So the Edmonton Construction Association acknowledges that we are located on Treaty 6 territory and respects the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continue to enrich our vibrant community. Getting into some introductions here. Our panelists today are Tom Brooks, Jordan Crone, and Carrie Powell. Tom is a senior associate and litigation lawyer in Gowling's construction group. He's got lots of experience with construction claims and in particular builders' liens and payment issues. Jordan Crone, he's a partner and litigation lawyer in Gowling's construction group as well, with experience in large and complicated construction, engineering, and infrastructure claims involving litigation, mediation, or arbitration. And lastly, we've got Carrie Powell. He's the senior partner with Gowling Construction Group, and he's practiced construction law for close to 40 years and almost exclusively in the construction industry. So we've really put a panel together of some dedicated subject matter experts who are really going to be able to answer any questions you've got. Now, the way that the format of this session is going to go is that Gowling has broken up the session into a number of different modules, if you will. And what they'll do is they'll address questions on each module at sort of a predetermined time throughout the course of the webinar. So if you have any questions or something pops into your mind, just please enter it into the chat box, and then Gowling themselves will be monitoring the chat and make sure that they address those questions during those breaks in between each module. And lastly, at the end of the webinar, if for some reason you can't, you have to duck off early or you can't finish the webinar, ECA will be providing the slide deck, all of the FAQs and other information back to our members who are participating in today's webinar. So you will be getting some further information in hard copy on this. So with that, I will turn it over to Carrie Powell to kick us off. And thanks again to Gowling for being here today.
Thank you very much, David, and thanks for the members to help us inform you about this pretty impactful legislation that's going to come into effect in late August of this year. We do invite questions because we are collecting questions from the various webinars that we do to the different industry sectors, and we're going to publish those to the industry probably in early June, so that we'll have another set of FAQs from different sectors, and so everyone will know what everybody else is asking and concerned about the legislation. As David has said, we're going to go through 4 or 5 sections today. We do invite you to use the Q&A function. We'll try and stop at the end of each section to answer questions. If there's too many questions, we'll try to leave them to the end because I think it's important that we get through all the pieces, but please, we do really ask you to ask your questions. If you have some, we'd be pleased to try and answer them. We can't guarantee that we'll have all the answers. We've been stumped a couple times already, so we'll let Jordan lead us off. Thanks a lot, David.
Well, good afternoon and thanks everyone. I appreciate everyone joining us on a Friday afternoon. So without further ado, let's dive in and talk about what you need to know and how to get prepared with the Alberta Prompt Payment and Construction Lien Act. So what is it? Well, the Prompt Payment and Construction Lien Act is effectively a renaming of the Builders Lien Act that's going to introduce some new concepts. What are those new concepts? I think it's fair to think of them as about three distinct concepts. There's the changes to the existing Builders Lien Act. We have the introduction of prompt payment. And third, we have a fast-tracked adjudication process that is new and distinct. So really, the purpose of this legislation and the intent of it is to provide consistency and speed up payment throughout the entire construction industry. And it's also to give this sort of new fast-track way to resolve disputes that are outside of the core process, something separate and apart. So when do we need to get ready for? This is the date we've got to circle in our calendar. This is the, one of the key dates that we're all thinking about. This is the date, when we talk about be ready for, it's August 29th, 2022. So you can go circle that in your calendar now. This is the date that everything's going to effectively change that we're talking about here. So as we've talked about, and in our introductions, we've really been involved in this, Carrie in particular, for over a decade. We've got a ton of experience. We've been dealing with Service of Alberta and a number of industries as well, just to stay up to speed here. So we're going to use all of that knowledge, all of that experience. We're going to do our best today to sort of get you up to speed and let you know everything that we can about this. So who does it apply to? Well, this is maybe the first introduction. It's going to apply to anyone who is performing work, including services, furnishing goods or materials with respect to an improvement in land. Okay, it applies to any construction sector. It doesn't matter whether you're a home builder, it doesn't matter whether you're working on a large scale oil and gas project, or whether you're doing anything in between. It doesn't matter the delivery method that you're using or the type of contract or the arrangement, it applies to you. It also applies to owners, developers, consultants, and in Alberta, it can also apply to architects and professional engineers. Okay, so it's a bit different in that in Alberta, we do have it applying to architects and professional engineers, as long as they're registered as professionals and they're providing services with respect to an improvement. One of the other things here that's worth mentioning is it will apply to municipalities, county and regional authorities as well. So that includes any public-private partnership that you may have with those authorities. It will apply. So if you're doing something with a city or one of the municipalities or a county or regional authority, this will apply to your work so long as you're doing an improvement in land. So we talked about who it applies to. Let's talk about who it doesn't apply to. Well, it doesn't apply to the federal government. So if you're doing any federal government project, this will not apply. The federal government is going to be coming out with their own prompt payment legislation a little bit later. It's not in place now, but regardless, if you're working on a federal government project, this doesn't apply. Same thing, if you're dealing with the provincial government or doing a provincial government project, whether it be a public-private partnership involving the provincial government or it deals with the operation or maintenance of any sort of public-private partnership, this act doesn't apply. What's going to apply is what has traditionally applied, which is the Public Works Act. And so the government has left the Public Works Act in place, and that's what's going to apply. So you need to be thinking about, okay, what work am I doing? Am I doing anything for the federal or provincial government? Then this isn't going to apply. Now, if those don't apply in your instance, the question becomes, okay, will it apply to my project and what I'm doing? And the answer is yes, if you're doing an improvement to the land. Okay, the definition of an improvement in land hasn't changed from the existing Builders Lien Act. But just for those, and to remind everyone, what it really is it's anything that you're doing to the land. You can be constructing, building, placing, digging, drilling, that is affixed to the land. So if you do something that's not affixed to the land, it's not an improvement to the land. And Alberta courts over time have sort of manipulated this and treated this a little bit differently. So if you are doing such thing as designing or planning, permitting, even renovations or demolitions, those can be considered an improvement in land so long as they're intended to be used on the land. And that's sort of one of the things that's worth considering. And those would all be considered an improvement to the land. And in this instance, that means this is going to apply. It's also noteworthy that this act is going to apply whether you have a written contract or not. You can have a handshake deal and this act will still apply. The trick is you have to have some sort of agreement to provide work or services, and you have to do it with respect to an improvement in land. It can be that handshake agreement, and this act will still apply. You don't need to have a very formal written contract. So it will apply in a lot of instances across a number of different projects. So that takes us to Section A on payment, which is Tom Brooks's section. I know there's no questions usually at the outset, so we'll just continue on. Thank you.
Thanks, Mark Jordan. I'll be delving into the prompt payment aspects of the legislation. First thing that we say at the outset about this new prompt payment regime, next slide please, Jordan, is that it does not guarantee you payment. Rather, it mandates specific requirements with respect to the timing of invoicing, as well as the timing of disputes and notices, but it does not guarantee that you're going to be paid. What this means is that you will still want to avail yourself of all the available security to you, which will include registering a builder's lien if you are not paid on time, or claiming on labor material payment bonds if those are available. Having said that, let's delve directly into the prompt payment cycle itself. So, how it's supposed to work in the ideal situation is that the owner has 28 days to pay from receiving a proper invoice from a contractor. Now, that term proper invoice is important. We'll come back to it later. But what's key here is that the owner has 28 days to pay. The contractor, from receiving payment from the owner, then has 7 days to remit payment to his subcontractors. And then those subcontractors have 7 days from receiving payment from the contractor to pay their subcontractors. So we can see how funds flow down the construction chain in the next slide. You'll see here the same information, but you can see how funds are intended to flow. So contractors paid in 28 days, subcontractors should be paid in 35 days, and subs within 42 days. And that 7-day timeline cascades further down the construction chain. Now, this is the case where there are no disputes and funds flow freely through the project. The next slide deals with situations where there is a dispute in payment. What we find is that the forms for notices of dispute and notices of non-payment are the most effective way of understanding how the disputed payment is supposed to work. Now, we'll be going through the forms in more detail, but the key insights that hopefully we will leave you with are, firstly, that A, you need to be sure that if you dispute a payment, that you're sending the proper notice in the proper form, and B, if a party does send that kind of dispute notice or notice of non-payment, then there are going to be a series of cascading notices down the construction chain, advising everyone who is implicated that there is a dispute. So, in this diagram, on the left-hand side, we have situations where the owner disputes that some or all of the proper invoice rendered by the contractor is payable. In that situation, the owner has 14 days to issue his notice of dispute in Form 1. If the owner issues his Form 1 notice of dispute, then the contractor, 7 days after receiving it, has to then submit his Form 2 notice of non-payment to the subcontractors. Subcontractors then have 7 days to issue their corresponding notice of non-payment to their subcontractors. So you can see how it flows down the construction chain. On the right-hand side, we have a situation where the owner does indeed pay the contractor in full, but the contractor decides for whatever reason that the subcontractor should not be paid in full, in which case he issues his Form 3, or the subcontractor feels that his subcontractor should be paid in full, in which case he issues a Form 5. So as I said, we'll go into those in more detail shortly, but you can see how these forms cascade down the construction chain. But before we do that, we're going to discuss this key concept of the proper invoice. This is something that's new to the prompt payment legislation. A proper invoice is issued from the contractor to the owner, and it has to include specific information. This includes a description of the work or services performed, the amount due or owing, and in particular, the information identifying the authority under which the work or services were performed. Now, the wording there is authority as opposed to contract, which means conceivably that change orders to a contract can be considered within a proper invoice. These are the bare minimum that the legislation requires. The owner can require the contractor in the contract to satisfy additional obligations in his proper invoice. However, those additional obligations cannot contradict the requirements of the legislation.
Oh, Tom,
Important-
we're anticipating that the industry, including ECA, may get together and establish a standard form proper invoice so that the industry can be using, or at least have a guide to what a proper invoice looks like and what should be included in it. Because otherwise, subs will have to know what the owner's requiring of the contractor in their invoice in order to submit their invoice in a form that's going to satisfy the requirements that the contractor has to submit the proper invoice. So hopefully we can get together as an industry and develop something that most of us can follow as a guide.
Exactly, because what we anticipate is that whatever additional requirements that the contractor has to satisfy, he is going to ensure that his subcontractors have to satisfy them too, so that there are mirroring sets of information between subcontractor invoices and contractor invoices. So presently, because the definition of a proper invoice is so open-ended, or the information to be included is so open-ended, it will mean, at least until we agree upon a standard form of invoice, that the proper invoice format may differ between owners and between different projects. Importantly, your proper invoice should say it is a proper invoice, and if it doesn't count. But this opens up an opportunity, because what the Act permits and contemplates is, for example, that the contractor can send a draft invoice to the owner, allowing the owner to assess it beforehand without inadvertently triggering the prompt payment timelines. And then once it's agreed, the contractor can send his actual proper invoice for that amount and then trigger the prompt payment timelines.
That certainly is the practice we're seeing in other jurisdictions, particularly Ontario.
Next slide, please. So this proper invoice must be rendered by the contractor to the owner every 31 days. The Act doesn't contemplate different forms of invoicing. It expects every 31 days. The timeline can be shortened by contract, but it cannot be extended. So 31 days is your maximum. That being said, the Act is silent on the questions of milestone, lump sum, phased, or annual progress payments. What this means is that a contractor can satisfy his invoicing requirement for every 31 days by issuing a nil or nominal value proper invoice, and then invoice in addition at the various milestones. And thereby you can turn this monthly invoicing into a phased basis, should you wish, so long as you're still rendering those monthly or every 31 days proper invoices. Now, it is important that parties know when the proper invoice is being issued by the contractor. And we'll get more into the rights to information later, but I'll flag here that there are opportunities under the Act to demand information from the owner or the contractor with respect to the state of accounts and the prime contract, in order to evaluate when a proper invoice has been issued or should be issued. Next slide, please. So I spoke about this 31-day timeline, and the point I want to make on this slide is that when we're talking about days, we're not talking about working days, we're talking about actual days, which means every single day counts. Now, this hasn't changed. Under the Builders Lien Act, you have 45 days from the last day of work to register your builder's lien. And the situation there is that if that 45th day falls upon a Sunday or a statutory holiday, you get carried over until the next day that isn't a holiday. And the same principle will apply, for example, to your proper invoices. Similarly, the same principle will apply to all of the notices of non-payment and notices of dispute that we'll talk about shortly, i.e., all the deadlines are calculated in days and not working days. And what this can mean is that your proper invoices or your notices of dispute may fall on a Saturday. The exception are certain adjudication timelines, which under the regulation to the Prompt Payment Act are expressed in calendar days, and these are defined to exclude Saturdays. So what this means is that certain adjudication timelines can only fall on weekdays, whereas conceivably certain deadlines for everything else might not. Next slide, please. So we've talked about the proper invoice, and we've talked about how regularly it needs to be rendered. Let's talk about preconditions to a proper invoice. The Act disallows certification or approval by the owner as being a precondition of a proper invoice. What this means is that the owner can't say that until the invoice is certified, it doesn't count as a proper invoice, triggering prompt payment. Rather, the owner has 14 days from receiving the contractor's proper invoice to issue his notice of dispute, indicating that some or all of the proper invoice is going to be paid. Now, this has an important result. Because the owner only has these 14 days to issue his notice of dispute, that means that if you do have a cost consultant, you're going to have to get them in, evaluating the work and providing that certificate within those 14 days. In addition, there are opportunities for pay when paid clauses. In the earlier version of the Act, pay when paid was explicitly disallowed. That is no longer the case. However, if you do have a pay when paid clause, it still needs to comply with the requirements of the legislation, and in particular, the timelines for payment and the timelines for issuing notices of dispute. So we've talked about unacceptable preconditions. Let's talk about acceptable preconditions to a proper invoice. Commissioning and testing of the improvement can be considered an acceptable precondition to a proper invoice. What this means is that as long as the contract provides, until an improvement is commissioned and passes or tested and passes, the contractor can't issue a proper invoice for it. Again, this has to be stated in the contract. Additionally, we expect that certain requirements such as statutory declarations and WCB clearances will still be required by owners, and they are acceptable preconditions for a proper invoice. And lastly, we note that the owner is entitled to claim a set-off against any amounts owed to a contractor under a proper invoice. That's still permitted, but the owner is going to have to identify the reasons for that set-off in his notice of dispute.
Just to make a point, Tom, the legislation, correct me if I'm wrong, does not define commissioning or testing.
Correct. The Act doesn't define either of those terms. It's going to be left to the contract. So you're going to want to have to pay particular attention to those clauses if your contract requires commissioning and testing prior to a proper invoice. Next slide, please. So let's get into what happens if there is a non-payment on the construction chain. So as I alluded to before, there are 5 forms. We'll go through these in quick detail, just so you can see how they flow down the construction chain, and importantly, how disputes are supposed to be resolved quickly if a payment dispute arises. So we'll start with Form 1. This is the owner's notice of dispute. This indicates to the contractor that the owner disputes paying some or all of the proper invoice. As I mentioned earlier, the owner only has 14 days from receiving that proper invoice to issue this notice of dispute. It's a tight timeline. And importantly, the Form 1 notice of dispute must include the full particulars of the owner's reasons for non-payment. I pause to note here that the owner is still obligated to keep his 10% holdback from the contractor. This does not count as a dispute. This doesn't trigger a notice of dispute. This is still regular. Now that brings me to Form 2, which is the mirror form for the contractor. So in this scenario, the owner has issued his Form 1 notice of dispute, indicating that he's not going to pay in full. If the contractor receives this, then he sends the notice of non-payment in Form 2 to any of the subcontractors who are implicated in the payment dispute. The contractor has 7 days to do this. Importantly, within this Form 2, the contractor undertakes to take the owner to an adjudication within 21 days. What this means is that the dispute about payment will be taken to an adjudication very quickly in order to be resolved.
And Tom, this is a really important point, because if the contractor does not give the notice or does not take or undertake to take the matter to an adjudication, the contractor has the obligation to pay, notwithstanding the dispute with the owner.
Exactly. The contractor has to render this Form 2 if he intends not to pay his subcontractors. And in so doing, he commits to taking the owner to an adjudication.
It's a key component of the prompt payment legislation, because it forces action to be taken on a dispute so it doesn't linger or be ignored for the duration of the project and never get addressed.
Yes.
And guys, this
Yeah.
sort of is, there's a question here that might apply directly. So Dan asks, what is the purpose, and he goes back to the nil invoice you were talking about, Tom, but what is the purpose of a nil invoice every 31 days? What are we expecting as a response of the nil invoice? And I think that question ties in here. Do you have a response for the purpose of a nil invoice?
Well, so obviously it depends upon your contract terms. I think you may want to, I think we said nominal in our slide. Nil, I suppose, is potential as well. If in fact the owner isn't disputing whatever the content of the proper invoice is, then it's not going to trigger this notice of dispute. And so it's not going to trigger these flurry of adjudications and so forth. And if you did issue a nil invoice, then you wouldn't have anything to adjudicate about. The reason why we bring up that idea is because it, in some cases, is technically required by the Act if the parties intend to have, say, a phased payment basis, but need to comply with the invoicing requirements of the Act.
The intention of the 31 days, if you look at the Ontario legislation, it doesn't have a 31-day period. The obligation to pay starts when the invoice is issued, but a person, a contractor, or someone can hold back from invoicing and thereby delaying any obligation to pay. The 31 days is intended to compel parties to invoice in a timely manner. So the nil invoice is merely someone complying with the 31-day requirement to meet the technical requirements of the Act. That's all it really is. Yeah. And so if you don't issue the invoice in 31 days, there's really no ramification to that. You're not invoicing for anything to get paid, and you won't get paid because you're not invoicing for anything. So all it is a technical requirement with the Act itself. So you're not offside the Act. That's all it really is.
So I'll move next to Form 3. This is the scenario instead where the contractor has been paid in full by the owner, but the contractor has decided that some or all of the subcontractors should not be paid in full. In this case, the contractor has to issue his Form 3 to those subcontractors within 35 days of his proper invoice. And this form must include detailed particulars as to the reasons for non-payment. If the contractor does not provide this notice within those 35 days, then he becomes obligated to pay those subcontractors in full. So there are two final forms, and they both belong to the subcontractors. The next is the Form 4. So this applies in the scenario where the owner has issued his Form 1, notice of dispute, to the contractor, saying he's not going to pay in full. The contractor has then sent a Form 2 to the implicated subcontractors, indicating he hasn't been paid in full. Those subcontractors then send a Form 4 notice of non-payment to their subcontractors who are implicated in the payment dispute. And again, they have a 7-day requirement to send this form. And similar to the Form 2 of the contractor, the subcontractor undertakes to take the contractor to an adjudication within 21 days. So what this means is that we're going to have both a cascading set of forms down the construction chain if there's a payment dispute, but then a series of cascading adjudications up the construction chain from subcontractor to contractor to owner in order to remedy the payment dispute as quickly as possible. The last form that we'll discuss is the Subcontractors Form 5. This is essentially the Subcontractors Form of Form 3, which we discussed, i.e. the subcontractor has been paid in full by the contractor, but he feels that some of his subcontractors should not be paid in full. If that's the case, then he has to provide the Form 5 Notice of Non-Payment Dispute within 42 days of the proper invoice. Again, this must set out the full particulars of the reason for the non-payment dispute. And again, if the subcontractor does not provide this notice in proper form within the 42-day time period, the subcontractor is obligated to pay its subcontractors in full.
So Tom, as we said, these forms are determined by a regulation, but we'll provide a copy of Forms 1 to 5 to David to circulate to members and attendees as he sees fit. So you don't have to search for these. The forms are fairly simplistic, but you're required to use the actual form themselves.
Great, thanks, Kerry. So now we'll look at what happens when we receive one of these forms. So if there's a partial payment, what do we do? So the contractor is the one that's responsible for figuring out which subcontractor's work the owner hasn't paid for. If the amount not paid by the owner relates to one or more subcontractors' work, then the contractor pays those implicated subcontractors proportionally from whatever funds were received from the owner. All of the subcontractors not involved in the payment dispute get paid in full. However, if the amount not paid by the owner cannot be directly related to a particular subcontractor or subcontractor's work, then the contractor has to pay all subcontractors proportionally from whatever amount was paid by the owner. A similar process applies if the contractor short pays the subcontractor. That subcontractor has to figure out which of his subcontractors are involved in the payment dispute. Importantly, and the key lesson that we want to underline when we're discussing all of these forms of disputes is owners, contractors, and subcontractors have to pay all amounts that are not subject to a notice of non-payment or notice of dispute. So this means if you do want to dispute a payment, you're going to want to make sure that you send the proper form within the proper deadline.
And it won't hold up if there's a glitch in the invoicing, or it won't hold up the payment of the majority of the invoice if there's a minor dispute. Where, in the past, we've seen situations where there's a small issue and therefore the entire invoice is thrown out and not paid. This will change that.
So we end this section here with a reminder of the key timelines. And this is perhaps a particular slide that you'll want to print out and have available to you just so you can see the timelines more easily. So to review, the contractor has his 31-day requirement to issue his proper invoices. The owner has 14 days to issue a notice of dispute about any amounts. Any amounts that aren't disputed have to be paid 28 days after the proper invoice. And as a result, the subcontractors should be paid within 35 days and subs within 42 days. So this brings me to the next section. I'll pause here and we can answer some questions pertaining to the prompt payment aspects.
Perfect. So Tom, I've got some questions here for you and Kerry. The first one comes from Dan and he asks, does prompt payment still apply between a contractor and his subs, even if the contractor's contract is with the province? You got a sub doing work for the contractor.
So if the contractor's contract is with the province, then very likely you are not falling under prompt payment, you're falling under the Public Works Act, in which case the answer is no. So it's the nature of the improvement and who it is for that will govern. So in this scenario, no.
So we got a question from an anonymous attendee, which is, what is the date of issuance? Is it the date on the invoice or the date of receiving the invoice?
The Act isn't clear about that precisely. It won't be the date on the invoice. I suspect it would be on the date that the contractor sends the invoice. However, you're going to run into difficulties if, for example, you send it by mail and it takes some time to get to the owner. So presumably, or in most scenarios, you're going to be sending it electronically. An owner, I think, will have a reasonable basis to say that his 28 days start when he receives the invoice as opposed to when you popped it in the mail.
Yeah, I think it'll be based on receipt. The problem with that is that how does one know when he receives it? Like, how do the subs whose time periods are for dispute, et cetera, are dependent upon, and payment are dependent upon the date that the proper invoice is received? So there is a bit of a hole there that needs to be filled.
Yeah, absolutely. Jennifer has a question, and she asks, how do you pay an invoice that's incorrect?
So if you dispute some aspect of the invoice from the contractor, then the owner has to pay whatever amount is not in dispute and to issue a notice of dispute for any amount that is in dispute. So we'll get later on to the sort of administrative aspects, but the short answer is you are going to have to adapt your accounting procedures to be able to partially pay invoices.
Mike's got a question, and he asked whether this legislation applies to insurance claims, and that sort of follows Ken's question when he asked whether this legislation applies to the federal government. So maybe you could talk about whether it deals with insurance claims and companies and whether it applies to federal government contracts.
We'll get to insurance later, but as a prelude, if the work that the insurance company has retained a contractor for falls under the definition of improvement, then conceivably yes. What will govern is if there's an improvement. As to whether or not the legislation applies to federal contracts, the answer is no. This only applies to or this won't apply to federal undertakings because there is a federal Prompt Payment Act that I think is in the works. So you'll fall into that instead of falling into this prompt payment legislation.
I've got a couple anonymous questions that just came in. I think one of them here is, when submitting a proper invoice, should the contractor obtain a signed form confirming that the contractor received the invoice, just so the contractor can have sort of confirmation of date received? Does that seem like a practical way to manage this flow?
That is one way. It may be in some cases a little overkill. I suspect if you're sending it electronically, say by email, then a read receipt was probably sufficient. If you're sending it by a courier, then the courier's the signatory for the courier might be sufficient. So you don't necessarily need a signed form, but you will want to obtain some form of proof that the owner has received the invoice. And I think owners, to make things easy, will be best set by advising the contractor each time that they receive a proper invoice. So
last question here, we've got a sort of a great one, I think, but it's from an anonymous person who says, are we obligated to notify the owner of an issue of non-payment between the contractor and subcontractor? So they're doing a Form 3, but does it go down to the sub and up to the owner, or does it go just to the sub?
This goes down as opposed to up. So technically the owner won't know.
All right, Tom, I'll let you continue on.
Thank you very much. So next section we're going to move to our builder's liens and holdbacks. So can a party still register a builder's lien? The answer is yes. Your rights to register a builder's lien are not affected by the new prompt payment legislation. And this is the case even if a party is involved in an adjudication process. So you can register your builder's lien anytime that you've performed work for which you have not been paid. And importantly, as with the present Builders Lien Act, parties still cannot contract out of or release or waive their lien rights. What this means is that if the contract says that the Prompt Payment Act doesn't apply, or the contract seeks to avoid the Prompt Payment Act, those clauses will be void and the prompt payment legislation will apply. So what has changed in respect to builders' liens are the registration times. So the standard registration time under the present Builders' Lien Act is 45 days. That is being increased to 60 days. Now, there are two exceptions to this. The first is for oil and gas wells and all oil and gas well sites, which, as with the current Builders' Lien Act, get a 90-day Builders' Lien period. The additional exception that has now been added is that for manufacturers and suppliers of ready-mix concrete, they also get a 90-day Builders' Lien period. It's important to note here that the installers of that concrete don't get the 90-day lien period. It's only the manufacturers and the suppliers. So you still need to hold the holdback from the contractor in the amount of 10%, and this hasn't changed from the existing Builders' Lien Act. And consistent with the existing Builders' Lien Act, the holdback between contractor and subcontractor remains a matter of contract and isn't required by the legislation. Now, there are some impacts to your holdbacks. Firstly, as I mentioned, that ready-mix concrete suppliers get a 90-day lien period. This means that their holdback is going to be held for longer. It's going to be held for 90 days when everyone else's is going to be 60 days. The only other exception that this act provides is that for contracts over $10 million, the holdback has to be released by the owner to the contractor annually. So just to pause on this, this is the only requirement under the Act for progressive release of holdback to the contractor. It's open to the parties to negotiate more favorable circumstances in which holdback is progressively released, but this is the minimum requirement if that prime contract is over $10 million. Next slide, please. So I mentioned holdback between contractor and owner. Let's talk about holdback between contractor and subcontractor. That holdback can be progressively released to subcontractors if it is agreed in the subcontract. The Act hasn't changed that. For most subcontractors, the holdback will be released after 60 days, because remember, there's a 60-day Builders' Lien period. But however, for the concrete suppliers, or for those working on oil and gas well sites, their holdback will be released after 90 days because of their 90-day Builders' Lien period. Now, importantly, if a contractor is agreeing with a sub to progressively release his holdback, the contractor will want to make sure that there are similar mirroring progressive release of holdback provisions in the prime contract to ensure that funds flow down from owner to contractor and then to subcontractor. A couple of other changes. So firstly, to substantial performance. So substantial performance still applies. You still have to issue a certificate of substantial performance. That hasn't changed. The only thing that has changed is that you can now issue a certificate of substantial performance electronically if that is provided in the prime contract. If that is the case, then you don't need to post your certificate to the project site. But if the contract doesn't say either way, then the default is you still have to post it to the project site. Alberta's legislation is really quite open-ended about how you're supposed to send it electronically. So other jurisdictions will require you to post your certificate in an industry publication or to send the certificate to everyone directly involved in the project. The Albertan legislation does not elaborate to that effect. It simply says that if the contract provides for electronic posting, you are permitted to do so.
There's an effort underway by the associations in Alberta to have a central place. And David, I don't know whether you want to make a comment on that or not, but there is an effort underway to ensure that there's a central place for the posting of certificates. And they're talking about using BuildWorks and making sure that it's cost efficient and everybody will know to look there, so that people aren't looking all over the place to find certificates. It'll give some predictability to this issue.
Yeah, thanks, Kerry. You took the words right out of my mouth, and I was just going to mention that. So, that is something that not just ECA, but all of the local construction associations in Alberta are looking to do. So we have a joint venture with respect to BuildWorks, and we are looking to be able to post through BuildWorks itself or some type of a module or attachment to BuildWorks. So yeah, exactly. It makes things a little easier, not looking around for it everywhere, and it's available at cost recovery on our part. So it wouldn't be a profit center by any stretch. It would be a member service.
Thank you.
Next slide, please. So last change that's important are the rights to information. So under the present Builders Lien Act, a party can demand certain information from contractor, owner, or subcontractor. And those rights are essentially the same, but slightly expanded under the prompt payment legislation. So specifically, anyone working on an improvement can demand that the owner or contractor or subcontractor provide within 6 days either a copy of the prime contract or subcontract, or a statement of accounts between the owner and contractor, or contractor and subcontractor. So these are intended to work essentially from the bottom up, so the owner can't issue demands to try and get access to copies of subcontracts, for example. This is a potentially powerful remedy because it allows you to access the prime contract, so you can see what the proper invoicing requirements are and the timelines are. It also allows you to see the statement of accounts between the owner and contractor to see when proper invoices were rendered and whether they were paid. We do expect that there will be permission for redactions for commercially sensitive information. So the Act doesn't say either way, but the purpose of these provisions is to permit someone to understand the status of invoicing. So we suspect that a court would be permissive of redactions that were reasonable in order to protect commercially sensitive information. So that brings to a close the Builders Lien section. I'll pause here and answer some more questions before I turn it over to Jordan for his section on adjudication.
So, we've got 2 questions. They don't actually necessarily go fully into the builder's spot, but I think they should both be answered. Christopher asks, if the Form 3 is issued and a dispute between the contractor and sub is beginning, because the owner won't know as stated, but would that mean the stat deck forms the next month require the contractor to disclose the dispute?
So the simple answer is it depends on your stat deck. So I think the standard CCDC one says that you paid your subcontractor in full, subject to legitimate disputes. So in that situation, that kind of wording would still permit you to, truthfully sign your stat deck while continuing your dispute with the subcontractor. But depending upon the wording of your stat deck, conceivably the answer is yes. But the Prompt Payment Act itself doesn't really include any information on that.
And then we had a question from Tim. He says, and this is the $10 million values. He says, is it total contract 10 million or is it 10 million payment within the year?
Pertaining to the mandatory progressive release of holdback, it is $10 million of the whole contract rather than $10 million per year. Lastly, I see a long question here.
Yeah, so I think, well, why don't we give that one a read, and we can come back to that one maybe at the end of adjudication here.
Sounds good. I'll send it over to you.
Great, thanks. So this takes us to the adjudication section, and this adjudication is a new concept. It's brand new. It's part of this act, and it's not something we've had before. So maybe the first question is, okay, what is adjudication? And the answer really is it's designed to be this sort of fast track dispute resolution process. It's got a new name. It's called adjudication, and we really need to be careful in not confusing it with arbitration. I may use arbitration inadvertently here, but because it's really easy to do. But the adjudication process is wholly separate and apart. The adjudication, it has a certified appointment, an appointment of a certified adjudicator, and they're going to look at a payment dispute between the parties with respect to the contract or subcontract. Now, what's interesting about the adjudication is the process is very streamlined. Unlike a traditional court process or a traditional arbitration, there is no oral hearing, there are no sworn affidavits, no questioning, no cross-examination. All you're doing in an adjudication is basically submitting written notice or a written argument with documents, supporting documents. That's it. It's one submission that you make to the adjudicator. There's no other questioning. There's no oral submissions. It is very quick. And when I talk about how quick it is, I'll show you on the next slide the timeline of how fast this process is intended to work. So, you know, it really has predetermined and set dates so that this process moves as fast and as timely as possible. The other thing that's, you know, so interesting about this is once the parties have provided their written submissions, the adjudicator is required to make a decision within 30 days. So you're going all the way, you know, and effectively getting a decision within 30 days, unlike a traditional court process where there is no mandate for when the trier of fact will actually make a decision. Here you have a requirement that will be done within 30 days. So we'll talk about this a lot in getting ready, but, you know, I want to highlight it now. It really is one of the key to success in this process is having your project records organized. You're going to have to be able to access them. You're going to have to be able to pull pieces from them, distill the issue down in a very, very tight timeline. So I keep talking about the timeline. So let's look at them. If we look at the far left, we have the notice of adjudication to the nominating authority. Okay, so this is you sending your notice of adjudication, and what you do in this instance is you provide it to the other party and the nominating authority. You have the ability under the Act to agree to a specific adjudicator. I'll talk a little bit more about that later, but you can't actually in your contract agree to a specific adjudicator. You can agree to a nominating authority, but once you provide the notice of adjudication, the parties can get together, look at the rosters from a nominating authority and pick an adjudicator. If you can't agree to an adjudicator, the nominating authority will appoint one for you. Okay, and they're going to basically appoint one for you within this 11-day period, so day 11. The party who then submitted the notice of adjudication has 5 days. That's it, 5 days to do their notice of provide their notice with the records, basically make their submissions. The party who received the notice of adjudication, upon receiving those documents and, you know, the argument effectively, will have 12 days to respond. That's it. That takes us to 28 days at the maximum. So that's the parties couldn't agree to an adjudicator. One had to be appointed, and one was appointed on day 11. So, and of course, this can happen faster. If you'd agree to an adjudicator on day 1, you know, your submission is going to be due 5 days after that. So let's say in this instance, that's right in the middle where we have day 28, okay? That's everything's been submitted to the adjudicator. The adjudicator now has 30 days. It's required, it's mandatory. They have to give a decision within the 30 days, except for a few, you know, abilities where they can ask for an additional 10 days if it becomes necessary or the parties agree that, you know, maybe the matter is really complex. So effectively, you're going from a notice of adjudication to a decision within 58 days. So it is very tight. It is very quick. You know, it is a fast-tracked process. We keep using that term. And the other thing that's sort of interesting about it is you're going to get an adjudication order, and it'll get certified by the nominating authority, and you have a couple options from there. So there'll be 30 days for them to pay. If they don't pay, you have certain rights that you may be able to use, or you can apply if you don't like the decision for judicial review. And we'll talk a little bit about judicial review, but I want to focus on how narrow judicial review is. It really isn't, I didn't like the decision, I should apply for judicial review. So firstly, what can be the subject matter of an adjudication? Well, the Act is very clear. It has to deal with the valuation of worker services provided. Okay, so if it deals with a issue of non-payment, it can be with respect to an invoice that's due and owing but remains unpaid. It can be with respect to change orders, whether they're approved or not, even proposed change orders you can deal with, or with release of holdback. Those are all dealing with valuation of work or services, goods, materials sort of being provided. Now, those automatically can be adjudicated. The other things that can be adjudicated is if the parties get together and say, listen, we've got a dispute here and we need some sort of resolution, but it doesn't deal with valuation of work. Let's go to adjudication. So the parties, you can actually agree to take a matter to adjudication that's not dealing with the valuation of work, okay? And in those instances, as long as the parties agree, it can go to adjudication. Now, not everything can be adjudicated, okay? So if it doesn't deal with valuation and the parties don't agree, you can't send it to an adjudication. The other thing that's worth noting here is this adjudication process, and there was a question about this earlier, you know, if you have in your contract, you know, the notion of, oh, your disputes have to go to mediation, or they have to go to arbitration, or you have to go to a certain court, or even a certain, you know, you're doing the work in Alberta, but, you know, oh, you have to go to a court in New York. You know, maybe that's a term that some people have seen. Doesn't matter. Okay, as long as the dispute doesn't have an existing court proceeding on the exact same issue, you can proceed with an adjudication. So that's a bit of a unique wrinkle here in that it sort of almost is separate and apart from what your contract may say, so long as there isn't an existing court proceeding. Now, the adjudicator also has a bit of discretion in this instance. So if the adjudicator looks at this matter and, you know, they get appointed and they're looking at it and they decide that, wow, this dispute really is frivolous or vexatious, then the adjudicator can actually refuse to hear the matter. The other thing that's really sort of, I think, important to consider in this is when you can go to adjudication. You can go to adjudication anytime during the contract, but not after the completion of the contract. So you have to make sure that you're sending your notice of adjudication or you're adjudicating something with respect to payment during the life of the contract, because you can't avail yourself of this option after. So how do we initiate an adjudication? Well, what you do is you provide the form, of course, that is a formal notice of adjudication. You're going to provide it to the other party who you're adjudicating or have a dispute with, and you'll send it to the applicable nominating authority that's in your contract. So once you have done a notice of adjudication, it becomes mandatory. So there's no choice. A party can't avoid this. The process has to happen. So one of the things people are sort of curious about this adjudication process is, okay, well, it's fast justice, but is it private and confidential? And the answer is yes. The proceedings and your submissions, those are all private and confidential. Okay, this process doesn't occur in sort of any public forum or anything like that. And what you submit to the adjudicator, so if you're submitting your contracts, etc., those are not going to be publicly filed. However, if the adjudicator makes an order and that order gets registered with the court for enforcement purposes, once you register the document with the court, it becomes a matter of public record. So i.e. anyone can go down to the courthouse and they can search for that document. To be fair, it's a very cumbersome process, and mostly lawyers are doing things like that, but it is certainly a possibility that it could become public record only if it becomes registered with the court. And it doesn't automatically become registered with the court if you don't need the enforcement mechanisms. So people often are asking, okay, who are these adjudicators and what is the nominating authority? Now, I think it's worth noting that you are able to agree on an adjudicator once you have your notice of adjudication, but you can't actually pre-name a specific adjudicator in your contract or subcontract. What you can is pick a nominating authority. And the way I like to think of these nominating authorities is they're sort of like a body up above the adjudicators, and they're responsible for administering this whole adjudication process. So they're going to be responsible for educating, qualifying, and appointing our adjudicators. Now, as far as with respect to who the adjudicators are, when we look at the experience in Ontario, we're finding that these adjudicators tend to be industry experts. And one of the things is, they have to have certain qualifications. And one of them is 10 years of sort of industry experience. And so that tends to mean that these people have been in the industry for a long time. They're industry experts and they know sort of what's going on. And one of the nice things is you can look at the roster and you may see names that you're familiar with and they have experience maybe in a particular issue. Now, with that said, in Ontario in particular, there's not a lot of lawyers that are doing the adjudication process and being adjudicators. There are certainly some, but there are not a lot. So this process can be done sort of outside of lawyers is one way that this is really intended to happen. Now, that doesn't mean lawyers aren't involved, because they always are. But Kerry, I think you had a couple comments about how the nominating authorities are going to work in Alberta.
Sure. In Ontario, there's one nominating authority. We are hopeful in Alberta there will be more than one to choose from. There's an RFP pending from the government to the industry, and there are two entities that I'm aware of who are interested in becoming nominating authorities, both of which will enlist adjudicators who have in excess of 10 years experience in the industry. So that means you'll be getting, someone with some practical industry knowledge to adjudicate or determine an issue during the life of the project. The whole intent here is to move payment along, is not have issues that are in dispute sit indeterminately to the end of the contract and then be dealt with as part of the negotiations at the end of the project after the work is done. So adjudication is a key component of the prompt payment legislation. So we're hopeful that we're going to have two nominating authorities, so there'll be competitive pricing, and you'll have a choice of rosters, which adjudicators to choose from. It's happening as we speak, but it's better be in place by August in any event. The experience in Ontario has been that it took, in the first year, they only had something like 21 adjudications, and I think last year they had 55. So it does take a little time to grow. So we don't know how many adjudicators will be available initially, but I think over time we'll find the use of this particular process more common to deal with disputes, at least to initiate discussions with respect to disputes. They may not all go to adjudication. And Jordan, I think as you're going to say that some of the adjudications in Ontario, a large percentage resulted in settlements as opposed to going the distance in an adjudication process.
Yeah, and Kerry, one of the questions we often get that maybe I'll let you head off in advance is, who pays for the adjudications, and sort of what costs are we looking at for these, for having an adjudication and running an adjudication?
Well, the rates will be set, and I can guarantee they're going to be less than lawyers' rates, for sure. The intention is for it to be cost efficient, and that will be controlling the schedule of fees, and also the process itself is not nearly as lengthy as an arbitral or court process. So it should be and will be far less expensive.
Yeah, for example, Saskatchewan has done their process, and they have a table of rates, and the rates sort of slowly increase based on the quantum at a dispute. So they use complexity is determined by quantum. And I suspect something similar will be used here with respect to rates. And again, they're considerably less than lawyers' rates. So the next question comes in, okay, great. I've gone to my adjudication and I've got a decision from an adjudicator. Is it binding? And the answer is yes. The adjudicator's decision is binding on all the parties that are involved in the adjudication, subject to a couple of other things that may come up. So what can supersede an order from an adjudicator? Well, one is a court order that gets made in respect of the dispute. So if there's a subsequent court order that gets made, that will oversee or step over any adjudicator's decision. If a party applies for judicial review of the adjudicator's determination, the adjudicator's determination is going to be set aside pending that judicial review. And so we'll talk a little bit more about judicial review on the next slide. The other things that can step aside a binding decision would be if the parties agree. So let's say the parties have now gone to an adjudication and they both don't like the decision. They both say, this decision doesn't make sense. I'm not happy. And both parties are sort of thinking, well, now what do we do? The parties can actually agree to go and appoint an arbitrator following the conclusion of the adjudication process. So if you do decide to do that and you go and appoint an arbitrator, that will supersede any adjudicator's decision. And that's because the parties can also agree in writing to a resolution of the dispute separately. So this seems to be what happens, before an actual adjudicator's decision is happening frequently in Ontario, is the parties are agreeing to their own resolution dispute. I mean, it makes a lot of sense that you are saying, well, okay, what can I live with in this dispute, rather than letting an adjudicator who I've, given these submissions to making a decision for me that is binding. So what happens if you don't like the adjudicator's decision? Now, one of the options you have is judicial review, but judicial review is this incredibly narrow concept. It isn't just broadly, I don't like the adjudicator's decision. He didn't think about this fact. I gave him this invoice and I don't think he looked at it, or he really just didn't consider this argument that I made sufficiently. No, judicial review is very specific and very narrow, and it deals with issues that are procedural or some sort of misconduct on behalf of the adjudicator that results in unfairness. So, you're not seeing judicial review in many instances. It is incredibly narrow. But one of the interesting things about judicial review is that if an application is made for judicial review, the order of the adjudicator is stayed. So it's set aside. It's not enforceable during the decision on that judicial review. So that follows now. So we've kind of followed along. We've got our decision. So what happens if you go through this process and at the end of the day, you're still not paid? So if you haven't been paid after 30 days following it, you can apply to get a court order, and that will give you all the typical enforcement mechanisms as if it were a typical court order. So, garnishment, all that sort of fun things. The other thing that's interesting is, and Tom spoke about it earlier, and so did Carrie, about what you have to ask for when you specifically set out in your notice. And if you specifically ask for it and you set it out in your in your remedy section, or what you're asking from the adjudicator, you can have the ability, if you remain unpaid after 30 days, that's the successful party can stop performing work. Okay, so the trick is you have to expressly ask the adjudicator for this as a remedy at the time of making your submissions, and only then, if you ask for it and you're successful, can the adjudicator give it to you. So it's very, very important, that we think about this process at the outset and what we're looking for. So you can't just say, okay, I've got a dispute, I want the dispute resolved. The question is, okay, how do I want this dispute resolved? And if it still is unresolved, what will happen next? So there's sort of a logical chain that we need to be thinking about, and making sure that we're considering all of those options if we do end up in an adjudication and we want a certain remedy, because the ability to stop work is obviously very powerful, and you need to be careful if you're going to be stopping work, but this adjudicator's order can give you that ability. So the next section is consolidation. So if you have any questions about adjudication, throw them in the Q&A now, and we're happy to answer them. Otherwise, I'll deal with consolidation, which really deals with adjudication itself. So
we have a couple of questions here, Jordan, for adjudication.
Yeah, go ahead.
When does the adjudicator get appointed?
The adjudicator gets appointed once you send your notice to the nominating authority. So we saw that back above in the timeline sort of slide that we talked about there. Let's go. We can maybe go have a look back here. Right here. So what you're going to do, if you're looking at the left of this slide, you have your notice, and if you can agree to an adjudicator, you can appoint one right away. If you can't agree to one, you're going to send it to a nominating authority, and they'll have 7 days to appoint one.
Okay, next question is, typically how long does judicial review take?
Well, judicial review is going to take longer. I'm not sure there's a lovely sort of guaranteed timeline. It's you making an application to the court. I think it's reasonable that, depending on the application and the, what the parties are trying to do, it's going to be measured in months.
We're quite hopeful that this remedy of judicial review is not going to be abused in order to avoid a determination that imposes an obligation of payment on a party. Judicial review, in our experience, is very limited. And I'm hopeful that if it is misused for that purpose, that the courts will recognize that and dismiss the applications readily, which will then bring back into force the decision of the adjudicator. I think the courts, what we're hearing is they want to respect the decision of the parties to bring a dispute to adjudication, and they want to respect the decisions of the adjudicators. So I think a judicial review will not be an avenue to circumvent the adjudication process.
Yeah, I think the first one,
that's certainly my hope.
the first one in Alberta will be interesting to watch. And if it's inappropriate in any way, I suspect it will be sent down quickly and with costs. I think there will be cost consequences significantly. You know, there's a term here called solicitor and client costs, which is, you know, every dollar that the other side spends on lawyers, they would be able to recover, which is sort of the most drastic remedy. Now, something like that wouldn't surprise me in an instance if a judicial review was sort of brought improperly.
It's the same with the adjudication process. The adjudicator has the ability to decline taking on a dispute if they view it as being vexatious. So I'm hopeful that the adjudication process won't be misused or abused as well as a way of creating leverage on a particular issue. And if there's a repeat performance, I'm hopeful that the adjudicators will be sensitive to that and decline to hear adjudications that are initiated for the sole purpose of being a nuisance or gaining some position of leverage.
David, I see you wanted to answer one of the questions. Is that right?
I was just trying to help you out by answering the how the adjudication or the adjudicator gets appointed, and you, as I was typing it, you answered the questions.
Perfect. Well, that's great. So why don't we continue on down to consolidation, and we can, if there's some more questions that sort of flow in, we can go after that. So what I want to talk about on consolidation is there is the ability, so when you think about this sort of logically, there is a way that if the dispute were to happen, you could see how it would come down the chain very quickly, right? And there would be a cascading effect of adjudications because there's a whole bunch of non-payments happening. So what the Act has done is it's set up a way that if you get caught in the middle, so you're really not who the dispute is about, but you're part of this, you know, cascade of effects, you can actually apply to have all of the adjudications consolidated into one. The only trick with this is you have to go to the first adjudication and make the application to that adjudicator. You can't make this decision you can't make this application in your own adjudication if you're the 5th, 6th, 7th, even the second one. You have to go to the first one, and only that adjudicator has the ability to consolidate. So that takes us to our notion on the transition period. So I like to think about this transition period as sort of a lovely line in the sand, you know, right in the middle. So this is this August 9th, 2022 date that we talked about. And the trick with this, and I saw a question about this earlier, and I want to be very, very clear, nothing of this is in force until August 29th, 2022. Okay, that's the earliest it can come into effect. And the way it works is if you have a contract or a subcontract that's entered into after August 29th, 2022, this is going to apply. If it's before August 29th, 2022, this is not going to apply to you. Okay, all of the existing Builders Liens Act, all of the, you know, and pieces for there will apply if it's August 29th, 2022. The interesting thing is if you're a subcontractor, okay, and if you're looking at anything after August 29th, 2022, the question becomes, well, what do I do? I've entered into my subcontract, maybe it's September 1st, September 7th, October 8th, but what matters is the date of the main contract or the prime contract. Subcontracts are always going to follow the main contract up above whenever that was entered into. So in this instance, if the main contract was entered into in August 28th, 2022, none of this will apply. Okay, so if you're entering into a subcontract, you need to know the date that the main contract or the prime contract was entered into so that you know which act will apply. There's also a sort of an interesting piece here too, is if you're in a long-standing contract. So maybe you entered into a contract on August 28th, 2022, and it's going to last for longer than 2 years. The Act has given a bit of a grandfather period. They say, listen, that's great. That contract can remain in place untouched for 2 years. But on August 29th, 2024, everything's, all of your contracts, everything must comply with this new legislation. So at that point, you're going to have to figure out, and you're going to have to make the changes to the contract so that all the new provisions, prompt payment, extended lien periods, and adjudication all apply. So pause here. Are there any questions, Tom, or anything? Otherwise, I can go to my favorite section, which is getting prepared.
One, if this is from Robbie, if the timeline gets extended for payment, does the legislation set out an interest fee amount for the delayed payment, or is that something set out in the contracts that you're going to have to rely upon?
The Act does provide specifically for insurance. And
Right,
it provides,
interest, Gary.
Interest.
I'm sorry, for interest, I'm sorry. And it provides an alternative to your contract if your contract doesn't provide for it.
Yeah,
Is that your thinking, you guys? That's my recollection. That there is an
yeah, that's
entitlement
exactly
to
right.
interest. Yeah.
Yep. Your only problem is that the legislative interest rate is very
This is-
low.
It's a
So
small amount.
typically, you will want to agree to a higher rate in your contract.
It's what I wish I had on my mortgage.
Yeah, it's like under 1%. Yeah.
This other question I think we can answer. What if contracts are silent on progressive release? Tom, do you want to hit that one?
Yeah, if the contract is silent on progressive release of holdback, then it does not get progressively released. The Act only provides for that specific exception for progressive release of holdback, and that's for projects over 10 million that last over, projects over 10 million, the holdback has to be released annually. So if your contract is silent and that applies, then the Act will apply. But in all other circumstances, if your contract says nothing, then there is no progressive release of holdback.
Between the subs and the general, but between the general and the owner, does the Act not allow for progressive release?
It does, yes, but as I said, the Act requires progressive release if your contract is over $10 million. But in all other circumstances, it does not say either way, and so you're going to have to leave that to contract.
Okay, I'd like to answer this big long question by the anonymous attendee. Should we read it? Because I think it's a really good point. And just before we get into the last section, we're running
a little
minutes.
late, but yeah.
We've got 15 minutes, so maybe we'll wait to the end. Thanks, Jordan. Yeah.
Yeah, why don't we throw it at the end and make sure we get through getting prepared.
Yeah, I agree.
And then we can sort of answer all the questions at the end, and hopefully there's even more that flow in. So let's talk about getting prepared. And I think it's, the big question is, okay, we've done this whole presentation. This is a lot to digest. It's very complicated, and there are a lot of pieces. So how do we get ready? And the answer is there's a lot of things you need to do, and you may need some help. Okay, you may not be able to do this all by yourself, but one of the things you're going to have to do right at the outset is you're going to have to revise your contract documents to reflect all these new requirements. So in particular, you're going to have to make sure you're looking at your contract and it properly reflects what needs to be included in a proper invoice. Your contract's going to need to talk about the timing of invoicing and payment, including what happens if there's partial payments. If you have commissioning or testing requirements applicable to the work or scope of work, your contract needs to address that because this is particularly set out differently now. Your contract's going to need to be able to address the mandated times that are issuing for notices of dispute, notice of non-payment, including, I think it's really important that your contract talks about where do they go, and whom should they be sent to so that timely notice can be provided. So what's the method? Where do they go? And who in particular do they need to be sent to? And at the same time, your contract needs to set out, well, what happens if there's a notice of dispute? What if there's a notice of non-payment or notice of adjudication? So, I mean, I'll do one plug for us here. This will be the only plug. If this is something you need help with, we'd obviously be glad to help you with something like this in updating your contract documents. So there's even more to do, okay? People sort of are saying, okay, great, I've now fixed my contract, I feel really good, but that's not it. There's a lot more that needs to happen. And what needs to happen is you need to think about the administrative processes that are happening behind the scenes, because this payment regime is going to impact almost all of your internal team that you have behind. So they're going to affect your project managers, your accounting, your finance, and you're going to need to look at all of your internal processes and make sure they properly reflect and can deal with these new requirements. So things you got to look at as far as a list of things that we want you to consider. You're going to have to look at your procurement practices, your terms and conditions on tender calls, submissions, proposals, and quotes. You're going to have to think about your contracting approaches. So if you're doing any alternative delivery method, including project management or an integrated project delivery, how is that method going to properly deal with and reflect, and how are you going to manage that given the new prompt payment timelines that need to be followed along? You're going to look at your contract. Obviously, we've told you to look at your contract, but you're also going to have to look at all of the conditions of your contract, the supplementary conditions, all the forms and all the schedules that go with that contract, and make sure those too comply. Obviously, we're going to have to look at the content and issuing of the invoices. And one of the things we've talked about here is the notion of draft invoices. So you've got, you've now made sure you've got a proper invoice, but maybe it's going to be a situation where you're going to need to use a draft invoice in order to sort of head off disputes so that they're not happening and you're not triggering timelines that you effectively can't adhere to, and then you're forced into an adjudication. So one of the things we're seeing in Ontario, Carrie's talked about it, is using these draft invoices and the contractor issuing them to the owner so that we can, get more information and figure out if something's going to be disputed right away. You're going to be able to have to receive and process invoices in a very timely and quick fashion. And that includes if there's a partial payment and how do we apportion it. So you're going to have to be able to determine that very quickly and figure out, okay, well, what happens now? I've got a partial payment. Who does it apply to? Where do I send it? How do I apportion it? Or if I can't, how do I apportion it down pro rata to everybody? And really, this all comes back to managing your project documents. You are going to have to make sure your administrative team is managing these project documents in a really effective and controlled manner. Because as we talk about these administrative processes more, there's just so much to consider. And one of the things that we think is worth utilizing and thinking about is sort of adopting some sort of tickler or time management system so that you make sure all of these mandatory time periods are being complied with. There's a lot to remember. It's hard, I think, to be able to comply with all of this using just a notebook. You need to have some sort of reminder system because you're going to need to make sure you're issuing, you're getting receipt, you're processing, and you're doing payment of the proper invoices all within very particular timelines. If you have to certify the work and get that done, you need to make sure that you're getting that certifier within and the work certified within 14 days. I mean, that may affect your cash flow requirements because if you can't get it certified in time, you may run into cash flow issues. Again, there's now the differing holdback and lien periods, so you need to be thinking about those. And you need to figure out what happens if there's going to be notice of dispute or notice of non-payment and when they need to be issued, and make sure you're putting them in the proper form. So there's just a lot of time periods that you need to be thinking about and monitoring on a project at all times. So one of the things that clients have been telling us that they've really experienced and had difficulty with in Ontario is ensuring that their accounting systems are processing partially what happens when they get a sort of a partial payment. And some, I think you need to make sure that your accounting system can properly deal with a partial payment and how we deal with that. So what happens if there's only a partially approved invoice, and how do we manage, pay, and apportion that out? I think you're also going to have to think about, depending on what happens here, how you post a certificate of substantive performance electronically and make sure that you have access to what you need to do in order to do that. And again, at the bottom of almost every slide of getting ready, in the event of adjudication, you got to have your project documents. They've got to be up to date and they've got to be accessible in these very, very short timelines. So organization is key. So what else will the legislation affect? Well, the legislation is going to affect your construction financing terms because they may not align with all of your payment obligations. You're going to need to pay very specific attention to all of your financing arrangements, your payment certifications, and your cash flow, because borrowers, if a notice of dispute or non-payment happens, there certainly is a potential for there to be gaps in your construction draws. So you need to look at the timelines and make sure you don't have gaps. And if you do have gaps, what are you going to do? Okay, how are you going to finance or fill those gaps that are occurring? So one of the ways that people are dealing with this or thinking about managing these gaps and how to address this is the draft invoices. And that's why they're so popular and they're such a great tool that you can utilize. So think about how you're going to use your systems to issue draft invoices and get those out in a timely fashion so that you can get a response. So Carrie, I know this is a slide you wanted to talk about.
Well, Lien, we think that the adjudication process is intended to be fast and ready justice, and typically insurance issues are complicated. So we don't think adjudication is appropriate for insurance-based issues. And if you look at the legislation, it talks about the valuation of work and payment. So I don't think insurance is going to be part of the adjudication process. We don't believe that the adjudicator's decisions are going to be binding on parties' insurers. It'll be outside the realm of adjudication. One of the questions that was asked about insurance, whether the act will apply to insurance, is very interesting because in my experience, I've never seen, and Tom, maybe you can help me on this, but I've never seen an insurer file a builder's lien to collect premiums under an insurance policy. So I don't know whether an insurer would be subject to the prompt payment. You know, do they have to issue an invoice every 31 days to whoever they're providing? You know, is it an improvement to land? I don't think there's been a decision of the courts in relation to that. And my own view is that it would not be something that would be bound by the prompt payment legislation. Tom, quickly, what do you think?
Yeah, in the vast majority of circumstances, the answer is no.
Right.
I don't think so.
With respect to bonds in Ontario, bonding is a requirement under the legislation for public projects of a certain value. Bonds are not part of the legislation here, but notwithstanding that, we continue to recommend that bonds be used to ensure creditworthiness, performance, and payment under labor material payment bonds. And it's particularly in the cases of insolvency. There was one question that was asked, we haven't answered yet, that talked about insolvency. The Act does not protect from insolvency. Hopefully payments are made in a timely manner so that the impact of an insolvency is less than it would otherwise be if we didn't have the legislation. But bonds need to be in place, and your lien rights, obviously, for an insolvency. We think that the sureties will want to know more information about the gaps in your financing, and if there is a notice of dispute, they'll want to know about it and what the result is. So there may be more reporting requirements that the sureties will impose on their clients, but I think that's basically our initial analysis. Thanks, Jordan.
No, thank you. So one of the things that people are familiar with, or maybe more familiar with, is the Ontario prompt payment that's come into place. So how does Alberta different? Well, it's worth noting that in Ontario, both the public and private sectors are included in Ontario's prompt payment legislation. Same, the invoicing and payment obligations, they're very similar between Alberta and Ontario. What's different is Ontario includes procurement processes as part of this timeline. But here in Alberta, we view it as contract A, contract B. So the procurement process is not included as part of this. Carrie's touched on the bonds. And it's worth noting that the statutory lien periods are the same for all the parties. So we've got a couple of lessons learned from Ontario. I mean, we've really touched on these throughout our presentation, which is great. But I think one of the key lessons and one of the takeaways for people is that invoicing and payment in Ontario as a result of this process has really been happening in a more structured, reliable, and consistent basis. It really does seem to be a much more formal and reliable process for people. And I think that's one of the big positives that's come out of it. We've talked about draft invoices, and they really are a key that people have been using. All of our clients in Ontario are telling us about how important it is and important it has been that they have, quick access to their project records and they've kept them organized. And then the other thing we're finding and we hear about is the way that disputes are now sort of handled. Disputes don't sit on a desk. Carrie talked about this. They're brought up the chain, the food chain within a company faster, and there's sort of a push to get something settled before it gets all the way to an adjudication. So it gets up and decision makers ultimately make a decision because they don't want something going to adjudication. They'd rather, hold the cards themselves and be able to make their own determination. In fact, even in Ontario, 20% of the disputes that even make it to adjudication, they don't even get settled before the adjudicator makes their decision. They're able to work it out as a result of themselves. So there really is a push on behalf of all of the parties to resolve the disputes themselves. So this takes us to the last slide of our presentation, which is the to-do list. So this is the checklist. This is what we think, it's not an exhaustive checklist by any stretch of the imagination, but this is certainly the one you got to print out, put on your board, and make sure you're thinking about that you need to do for August 29th. So what do you got to do? Very briefly, you got to review and update the contract terms, including any supplementary conditions. You got to look at your procurement documents, your tender calls. You're going to have to look and maybe adjust your financing arrangements. You have to look at all of your invoicing, receipt, how you process payment, including any partial payments or apportionments. You're going to have to look at all of your certification processes. And you're going to want to make sure that all of the prompt payment timelines that we've talked about and everything and how it flows are all being properly reflected, and your administrative and project team are ready to deal with that. You're going to make sure that you've got a way to electronically post if that's applicable to you. And you're going to make sure that all of your payment timelines and you've got a tickler system in place to make sure that everything and all the new lien periods are not being missed. And what this really comes down to is you really need to make sure that your project management systems are in place, are prepared and robust, because this is it's going to happen fast and it's going to be a big change.
Thanks, Jordan.
So with that, that takes us to the end of our presentation. And I think what we'll do is I note the time. So I think we can say thank you very much to everybody, but we will answer any questions. We'll stay as late as we have to answering any questions. Carrie, do you want to make any closing remarks?
Well, I just want to thank David and his group and for the opportunity to, inform the industry in a consistent way. We don't know everything, and we get to learn. Some of the questions today have been really good. We get to learn by presenting as well, I think, as much as we probably advise you of. So it's beneficial for all of us. And again, we really appreciate the opportunity, David.
Yeah, and thanks again to Gowling and Carrie, Jordan, Tom, the rest of your team. Honestly, great presentation, tons of information, a lot to synthesize. I really like how you got the to-do list. I think that's going to be really useful to a lot of our members. So yeah, lots to consider. Now, just for those of our members who obviously maybe you didn't take a screenshot, we will be posting the slide deck, the frequently asked questions. We're also going to provide members access to those official forms. So whether those are the non-payment disputes, notice of adjudication forms, whatever it is, if it's an official form, we'll make sure that we provide access to it. So I'll turn it back over to you guys. If you want to continue answering questions, I think that's fantastic. But from our perspective, I really want to thank you guys for all the hard work on this, and also a special thanks to Taylor and Johnny from the ECA team to help coordinate, put this on as well. So,
thank you.
Thanks, guys.
Okay, Jordan, you want to lead us through the questions? Thank you, David.
I do, yeah. So I'll lead through the questions, and Jennifer said, can I see the last slide one more time? So I'm going to put us up on the to-do slide just so she can feel good about that one. And Jennifer, we will circulate it so you can print it out yourself, get it in a single piece, big page, and post it on your wall. So Carrie, I think you said you wanted to address the long question, and I think I'll read the long question as best I can. So it says, I see this act putting a lot more pressure on our working with our consultants. It is our practice to prepare our invoice, send to consultant for review and acceptance before final pass through to owner for payment. In between that time, there can be a couple of refinements to the invoice based on perceived progress by subtrades. We determine the acceptable progress and work with the subtrade. So we would not prepare a proper invoice till all this is done. With many projects, this makes ensuring consultants are more responsive and invoicing is started earlier. It does not seem feasible to use the dispute forms through this.
Tom, do you want to answer that, or do you want me to? I don't mind answering it all. I'm pleased to, because I think it's not only a question, it's a statement. That's exactly what's happening in Ontario, and I'm hopeful that's exactly what's going to happen here. Is that there will be less disputes because they'll be sorted out prior to the proper invoice being rendered. And those disputes that actually go to an adjudication are legitimate disputes that can't be agreed upon by the parties and need a third party to provide a persuasive opinion through the adjudication process. So it's a great question. It's more of a statement. It will become the practice, I believe, and it has become the practice in Ontario, and it's working there. We have talked to payment certifiers, and that's what they're saying. So if you're already doing that, or you see that, I think that's an excellent question, and that's what I hope happens. So whoever you are, anonymous, you've got it. You know what the solution is.
Should have put your name with it.
Yeah.
So that takes us to our question from
you win
Michael.
you win the TV, but we don't know who you are.
So Michael asked, do credit terms agreed to by both parties supersede this legislation, i.e. a supplier of permanent material with net 60 payment?
Tom, that's yours.
So the answer is no. The act supersedes over your contract, but there are interesting repercussions if, for example, you have a standing agreement that exists prior to August 29th of this year that is intended to continue for at least 2 years, because the present Builders Lien Act will apply as opposed to prompt payment for those 2 years, and then you get grandfathered in August 29th, 2024. So the short answer is no, but the slightly longer answer is if you have a standing contract, then you might get grandfathered in.
So Thanks, Tom. Anonymous has asked if the prime contract is greater than 10 million, but the subcontract are less than 10 million, does the progressive release still apply?
Yes. So the progressive release that I mentioned applies only between owner and contractor and says nothing about subcontractors. So if the contract's over $10 million, he should get his holdback annually, and the Act says nothing about what's supposed to happen with subcontractors. So that will be left to the subcontract. What that will conceivably mean would be if the contracts are all silent, the contractor gets his holdback annually, and the subcontractors don't necessarily, unless they've contracted in their subcontracts.
Got a question from Rich. Can you go over the pay when paid terms again? And will the Act allow for insolvency? So I think, Carrie, you touched on the insolvency, but maybe just briefly, if you could go over the pay when paid terms again.
And Tom, support me or contradict me when I talk about this, but the pay when paid terms as we know it now will no longer exist. The pay when paid terms under this legislation say that the obligation of the contractor to pay is based on being paid by the owner within that 28-day period. So when they receive the funds from the owner, their obligation then to pay down the chain starts on that 28th day, and they have 7 days to pay you. If they don't get paid, then they still have an obligation to you, but their obligation becomes to adjudicate and to determine whether the dispute from the owner to not pay is legitimate. And that works down the chain to subcontractor, et cetera. So pay when pay is a bit of a misnomer. The Act does in itself provide for pay when pay. But the terms as we see it now, I don't think are any longer applicable. The insolvency of the owner is a good question, because I believe, and Tom, correct me if I'm wrong, and Jordan, if a general contractor or a subcontractor complies with their obligation, they're not paid, there's a dispute, so they go to adjudication, they get a decision, and the party who's obligated to pay, whether it's an owner or contractor, goes insolvent, I'm not sure if they have an obligation to pay down the chain if they have complied with their responsibilities under the Act itself. What do you think? What do you think, Tom? What do you think, Jordan? The Act is silent on it, is it not?
It is. So it's still entirely possible, for example, that the owner or contractor can go insolvent. It's supposed to reduce insolvencies down the construction chain because there's supposed to be this quicker flow.
Correct.
But the prospect is still there, and the recourse will be outside of adjudications is registering your builder's liens, right? The land is always your ultimate security for payment.
So hopefully the impact of an insolvency will be less because there's less money due and owing because there's been timely payment, right? And secondly, you're still going to require on those other remedies and opportunities for security, i.e. builder's liens and labor and material payment bonds or performance bonds.
Yeah, ideally you only have one proper invoice's value unpaid if an owner goes insolvent, because he's consistently paid all the other
plus the holdup.
That's correct.
Yeah. Okay.
So thanks, guys. I think that's great discussion on that, and you're bang on.
So I guess the other point there was made right at the beginning of the session. This is not a silver bullet. It helps, but you still have to practice good credit practices and be aware of your accounts, the value of the work you're performing, and when you're getting paid.
Yeah, absolutely. So that takes us to a question from Justin. It says, do the general contractors only have 14 days to dispute an invoice from the subcontractors as well?
Not quite. So this 14-day timeline applies between owner and contractor. What really is supposed to happen, what the Act contemplates, is that the contractor sends up the invoice to the owner, and if the owner doesn't pay, then he starts sending down his notice of non-payment to subs. And he does that within 7 days of receiving the owner's notice of dispute. So technically the answer is no. In practice, it will be best to ensure that the subcontractor's invoice is appropriate to be included in a proper invoice. so that you don't end up with this cascade of dispute notices. But know that 14-day timeline doesn't apply between contractor and subcontractor.
And Tom, to sort of build on that, what happens if a subcontractor's invoice is not appropriate? What should you be doing in that instance?
Well, so therein lies what you should be doing is exchanging those draft invoices and ensuring that the subcontractor has remedied their invoice such that it can be included in your proper invoice. If they fail to do so, then you have two options. You either send it up anyway to the owner and see if the owner disputes it, or you don't include it in your proper invoice and you tell the subcontractor, I'm not including this until you fix it.
I think in answer to this question, my sense would be is the general contractor has what period of time? So the owner has an obligation to pay within 28 days. They have 14 days to object to that payment. If the general contractor receives payment from the owner, but then objects to the amount in the subcontractor's invoice, one would think it would be the 28 days plus 7 days, because they have 7 days to pay their subcontractor. So wouldn't it be 35 days that the general contractor has to object to the payment to its subcontractor? Am I missing that?
Well, indeed, in this case, if he's paid in full, he's going to use his Form 3, which indicates that he's been paid in full but disputes payment anyway. And indeed, that's 35 days after proper invoice is his
Correct.
deadline.
Yeah, so he has 7 days from the date that he should have received or did receive payment from the owner to object to a payment to a subcontractor. So in answer to that question, he doesn't have 14 days. He actually has a longer period of time to make that objection. Is that
sort it
fair?
out. Yeah, exactly. That's fair. And that gives you more time to sort it out, I think is also fair.
Correct. Good, a very, very good question. We haven't had that question yet, so thank you.
Yeah, I like that one. So this is from Christopher. So in the case of receipt of a Form 1 from the owner within the 14-day period, can the contractor revise the invoice respectively or in mutually agreeable manner without resetting the 28-day payment period?
This is a good question. I think technically if he resends his invoice as a proper invoice, at least according to the Act, it will reset your 28-day period.
I agree.
So that's why it's important to exchange that draft invoice beforehand so that you're not inadvertently resetting or applying different prompt payment periods through submitting multiple proper invoices.
Yeah, exactly. This is exactly why you need to properly use draft invoices. Last question we've got, and then there's no more. So, and it's from Anonymous. They say, who ultimately pays the adjudicator? Is it the disputor, disputee, or cost shared? I guess I'll add that in.
Jordan, you want to answer that one?
Yeah, so you're going to share the costs, unless, of course, you're the successful party, and then you can make an application. One of the things you'll ask for will be costs of the adjudication. And depending on the result, you may be able to recover the cost of paying for the adjudicator.
That's it.
All right. Well, I want to thank everyone who's remaining. There's still almost 90 of you on the call. That's fantastic for a Friday afternoon. It's beyond kind. So thank you again, everyone. It's been an absolute pleasure to spend this time with you and go through prompt payment.
Thank you.
All right. Thanks, everyone.
Thanks, David, again. Thanks, you guys. Have a great, safe weekend.
Thanks, everyone.
Okay.